Hello, everyone. Welcome to LAWS11068 on Alternative Dispute Resolution. My name is Manjo Oison, and I am your unit coordinator for this unit. A lot of you, I think, have enrolled in this unit because you have a personal interest in knowing about alternative dispute resolution. Some of you may actually have come across instances when you were actually involved in alternative dispute resolution processes, perhaps relating to mediation or conciliation, whether or not you were involved perhaps in a proceeding before the Administrative Appeals Tribunal, or it may have been in relation to a family law proceeding where alternative dispute resolution is a very prominent feature now in the legal circle or in the legal profession. And our point, therefore, is to try to determine what exactly is alternative dispute resolution and what exactly makes it alternative to what might be known as the judicial processes of dispute resolution. Is ADR, in fact, an alternative to judicial dispute resolution? Now, as lawyers or as future lawyers, you would typically be trained in resolving formal disputes through the courts. And you will come across, as we try to learn about the ADR in this unit, you will begin to learn that there are a lot of disadvantages to coming before the courts in order to have a dispute resolved. So for example, if you were to be a litigant, and let's assume that you have an issue about a parenting matter over a child, and so therefore, you may be involved, you might be a father, you might be a mom, and the relationship is broken down, and you have kids, you might have one or two kids between you. There will be property law matters on how to distribute common property between the spouses. Now, there is a problem, as you would probably think, if you were to bring these matters before the courts, one of which is, of course, the cost, because for you to have to undertake legal proceedings, perhaps to apply for a parenting order before the court, you might have to enlist the services of a lawyer, and that is pretty costly. And you would therefore consider the possibility of trying to resolve this particular matter in relation to parenting orders without having to go to court. Now, a lot of you, or a lot of us, have actually been involved in what is known as alternative dispute resolution through the process of negotiations. So with or without lawyers, we typically negotiate issues about conflicts with other parties, and it could be with the support of lawyers. But the point there is that negotiation is a process by which we try to resolve a dispute without having to come before the court. And oftentimes, however, negotiations may fail, and therefore we see the inevitability and the need to have a dispute resolved before the courts. And even then, even when we say that because negotiations have failed or discussions between lawyers have failed, and therefore we need to go to, before the court, we realize that some ADR processes, such as mediation and conciliation, are in fact part and parcel of the judicial processes. And so it will be important for us, therefore, to figure out what exactly is alternative dispute resolution and how does it relate in relation to court dispute resolution processes, and what exactly would be the role of lawyers in ADR. And so I welcome you to this particular unit, and I welcome you to this session. And our goal in this particular podcast session will be that after you complete this tutorial, you will be able to discuss and explain first the unit learning outcomes and unit topics, the role of ADR in conflicts and conflict resolution, what ADR is, the types of ADR, the benefits of ADR, and why lawyers should learn about ADR. So let's begin by looking at the unit learning outcome. So on successful completion of this unit, You will be able to discuss the range and operation of ADR methods and their relationship with litigation. You will develop and demonstrate skills in listening, negotiation, and mediation, together with the ability to design ADR processes and drafting appropriate documents to support an ethical dispute resolution design, research and critique and evaluate the ADR literature to assist with determining appropriate ADR processes in a given fact situation, outline the basic theoretical principles of dispute resolution systems and how to apply them to manage conflicts, and finally gain an appreciation of the ADR processes of international commercial arbitration or Australian Indigenous peoples. Again, one of the main reasons why ADR is an important subject to learn relates to the fact that in a lot of commercial documents today, there is typically a provision or a clause in a contractual document whereby the parties agree to submit a dispute to arbitration. That is typically a clause that is part of most commercial documents. And the reason for that is that the parties want to avoid having to go before the courts in order to have a dispute resolved. It could be that one of the provisions in a document or in a contract may be that the parties have to submit to mediation or conciliation. So it is important, therefore, for us to learn about ADR. And in terms of the unit topics, in this particular session, I will provide an overview and introduction to alternative dispute resolution. In future weeks, we talk about understanding and dealing with conflict, negotiation, mediation, conciliation, arbitration, other dispute resolution processes such as appraisals and determinations, early neutral evaluation, adjudication, court-appointed referees, and other dispute resolution processes. So, you're going to learn more about these dispute resolution processes in the course of this particular unit. And we will begin to talk about the statutory dispute resolution schemes as well. In other words, as we will see in this particular podcast and in the course of studying this unit, we realize that alternative dispute resolution processes are oftentimes, in fact, embedded in judicial dispute resolution processes, such as in family law proceedings or in civil disputes before the courts, particularly also in relation to commercial disputes. And in relation, for example, to matters or proceedings before the Administrative Appeals Tribunal, the Administrative Appeals Tribunal Act of 1975 Commonwealth also makes provisions for the use of alternative dispute resolution for the purpose of trying to resolve a dispute between a party and a government agency. We shall also in this unit discuss legal issues, some ethics and standards, concerns about ADR, and special issues in practice. So let's begin now by talking about, looking into or having an overview about alternative dispute resolution. Let's begin by acknowledging and recognizing that conflicts and disputes are as certain and inevitable as death and taxes. So we often hear, statements being made by people that the two things that are certain in life are death and taxes, and no one is able to escape from those realities. But it's not just death and taxes that we are all exposed to. We are constantly exposed to conflicts and disputes. Even when we were younger, we would have disputes perhaps with siblings, with friends, with classmates. And as we grow older, a lot of these conflicts and disputes constantly materialize as well, whether or not it's in relation to family relations or in relation to civil relationships where we try to enter into contracts with other individuals. It can also be in relation to commercial settings. It can also be in relation to the result of tortuous acts, or it could even be as a result of workplace accidents, or even regular accidents occurring on the roads. In relation to family law matters, for example, there could be disputes about property in relation to whatever property belongs to, to partners, and the dispute can relate to trying to determine, custody over the children, which in the family law setting is actually discussed in the context of parenting orders. So a lot of conflicts happen each time, and a lot of these conflicts happen almost even every day. Oftentimes, however, a lot of these conflicts and disputes do not, explode in such a way that there has to be an attempt to try to resolve the conflict before the courts, but sometimes they do. So we need to recognize that given that conflicts and disputes are really part and parcel of life, then we need to talk about, how do we resolve these disputes? Now, in the past, we would think that, if there is a dispute or there is a conflict, if you during the time when there were cavemen, perhaps they probably, hit each other and bonk each other on the head. And even today, a lot of conflicts are resolved that way. It could be teenagers, men hitting each other as a way to resolve the conflict. You could have conflicts. Sometimes you can also resolve conflicts through wars. And we see that happening even today, where there are conflicts happening all over the world, whether it's in Syria, or it's in Iraq or Afghanistan, or even the conflicts between China and India, or India and Pakistan, South Korea, North Korea, and so on. Conflicts continue to happen. Now, apart from conflicts in the international sphere, and they've got issues there on how to resolve these conflicts or disputes, as I mentioned, today, conflicts continue to happen. And for people, whether it's in a family law setting, or as I said, a contract law setting, people sometimes feel that, or the parties sometimes feel that they need to seek the intervention of a court in order to have a dispute resolved, simply because, the parties cannot agree between themselves on how to resolve an issue. So now, especially among lawyers and law students, we have often been trained that the way to resolve a dispute would have to be through the courts. And that is the reason why we need to learn about civil law, criminal law, torts, property, and so on. So we need to know about substantive law, because if you go before the court, you need to have a strong legal knowledge. And not only should we know about the substantive aspects of the law, but we also need to know the procedural aspects of the law in relation to requirements about civil procedure, for example, the filing of pleadings, having discussions about discovery, settlement, and so on. Now, there ought to be a concern among us, or even among lawyers, when we think that the only way to resolve a dispute is through the courts. Putting yourself, for example, in the shoes of a potential party litigant, imagine the uncertainty, the concerns, the weaknesses that you should envision in having to come before a court in order to have a dispute resolved. So if you examine, for example, as an example, a parenting matter involving a determination of, how many days a child should have with a father or a mother, for that particular matter to have to be resolved by a court, one of the basic problems we see would be costs. So there are costs involved in trying to apply for a parenting order before the court, because in general, number one, we have a system where it is the loser who pays the cost. So in common law, in the case of Garnett versus Bradley, an 1878 case in the UK, the common law court pointed out that costs followed the event, and that the party who was successful had them as a matter of right. So the common law courts have recognized that courts should be awarded to the victor or to the winner in a court proceeding. And we have statutory schemes now which enable both courts in the Commonwealth and in the states to award costs to the winner. And so imagine the costs involved for the loser in a legal proceeding before the court. It can be quite substantial, not only in the tens of thousands, but even hundreds of thousands if one were to lose a case before the court. And given the uncertainty, therefore, of knowing, knowing who might win in a court proceeding, oftentimes party litigants would be cautioned and reminded by the judges to try to settle the matter between themselves without having to seek the intervention of the court, especially because if the court has to intervene, trial has to be had, and the court has to render judgment, what would then happen is that there is a winner and there is a loser. And in that case, the loser will end up paying substantial costs to the winning party litigant. So there is an advantage, therefore, to avoiding having to wait for the judge to render judgment about a matter before it. Apart from that, before a party litigant can actually even come before the court, there will have to be the payment of lawyers' fees. Judges oftentimes, well, most of the time, are quite unhappy to have to deal with self-represented litigants in a courtroom, mainly because self-represented litigants are, lack the knowledge about the law or the procedures before the court, and they end up, courts would sometimes perceive them as wasting the court's time and wasting the court's resources. Having a solicitor represent a client would mean that whatever the client is attempting to present before the court would already have been given the opportunity by a solicitor for the purpose of examining whether there was merit to having to come before the court. But that would mean that for a party litigant to have to approach a lawyer to represent him or her, that represents a substantial amount in terms of having to invest in lawyers. So that's the other problem with having to go to court. There's also the issue of time, in the sense that even when an application has been made before the court, it may take at least a year before the court would even mention that particular application. And if you go to trial, that will even take longer. And given that there might be a backlog in court proceedings, it can take anywhere between 2 to 3 years before a final resolution is made by a court. And there would be instances when you would wish a resolution to be had sooner. Having to go to court also means that there is an emotional toll. There are emotions involved, and because of the uncertainty involved, there's a lot of stress, there's a lot of pressure. And so therefore, a lot of individuals who find themselves in a serious dispute would also wish to consider the possibility of having the dispute resolved outside of the court processes. And then, of course, there is the problem about uncertainty of outcomes. Given the fact that in many cases, if a decision has to be rendered by a judge, and in typical fashion, there's a winner and there is a loser. In other words, it's a win-lose situation for the party litigants. The uncertainty of outcomes can be very problematic. Whereas if parties in dispute were to consider alternative dispute resolution processes, potentially, they can carve for themselves an outcome that they can both live with, instead of leaving it to the courts. Especially because if judges have to make judicial determinations about matters before them, and they would solely rely on the law, that may not be the best way to approach a dispute. Sometimes there is a need for an examination of what might appear to be fair, or what might even appear to be convenient to the parties. So by examining alternative dispute resolution processes, there is therefore an opportunity for parties in dispute to try to arrive at an outcome that they can live with. And so we now look at alternative dispute resolution processes. Now, I need to point out as well that even though we speak of alternative dispute resolution as being an alternative to judicial dispute resolution, in many cases, as we see, and I think particularly in week 8 and week 9, and as I will discuss today, in a sense, it is not correct to say that ADR is in fact an alternative to judicial dispute resolution, because alternative dispute resolution may in fact be embedded within statutory schemes in judicial dispute resolution processes. But in general, alternative dispute resolution is understood as an umbrella term for processes other than judicial determination, in which an impartial person, an ADR practitioner, assists those in a dispute to resolve the issues between them. Now, what makes, therefore, if you look at the definition, what makes it an alternative dispute resolution is the fact that the determination about outcomes of a dispute does not rest with a judge, but rests through the assistance of an impartial person. It doesn't, however, mean that because you are using ADR, it doesn't mean that it is necessarily not part of a legal proceeding, because it could be. Because even, for example, in family law proceedings, it is now a requirement that before it will actually proceed, an application, for example, for a parenting order will in fact proceed, the parties are required by law, by the Family Law Act, to undertake mediation proceedings. Now, it will only be in those instances, for example, when there's evidence of domestic violence, that mediation will no longer be necessary. But in general, as far as family law proceedings are concerned, there is a statutory requirement that the parties must seek mediation before proceeding with a parenting order application before, for example, the Federal Circuit Court or the federal court. So let's examine alternative dispute resolution processes. There are many methods or types of alternative dispute resolution. We can have negotiation, mediation, conciliation, arbitration, early neutral evaluation, adjudication, court-appointed referees, partnering, and dispute resolution boards. Now, for this unit, we focus on the four more popular ADR methods, which are negotiation, mediation, conciliation, and arbitration. And in later weeks of this unit, we talk as well about the other ADR processes. Now, negotiation is an important alternative dispute resolution process, mainly because, number one, we do engage in negotiations every day to resolve disputes, to resolve conflicts, or to arrive at an outcome that would be desirable to us or to parties. So, for example, almost every day, if you're a parent, you negotiate with your kids. If you're a husband, you negotiate with your wife, or negotiate with your partner over things. It could be about cooking, it could be about cleaning, it could be negotiations about financial issues. And oftentimes, however, as we know, when there are serious issues in relation to family matters and there is a breakdown in the relationship, in other words, if the parties, if a couple is unable to resolve their major conflicts through negotiation on their own, then potentially they will have to consider having to come before the courts in order to resolve the dispute between them. We will also learn, however, that negotiation is one of the alternative dispute resolution processes that lawyers are in fact involved in. So, for example, if the parties can no longer resolve the issue between themselves, and they're considering, for example, having to come before the court to resolve the issue about the distribution of property between the couple, or to resolve an issue about parenting over children, the lawyers can come in by trying to negotiate with the lawyer of the other party on how to resolve these particular matters. So it can be formal negotiations between the lawyers. You will also notice that when it comes, for example, to property law matters between the parties, it is quite common for lawyers to be writing letters and negotiating with the other lawyer to arrive at a settlement or solution that is acceptable and fair to both parties without having to go to court. Again, because the lawyers realize that having to go to court is very costly and will take time. So if you were to be a lawyer, consider the fact that if you had to go to court, it's going to be it's going to waste a lot of your time. You'll be preparing pleadings, a lot of documents, and so on. And it might take years before there is a resolution. However, if as a lawyer, you're quite good with the negotiations, for all you know, from the time that a problem comes before you, within 2 to 3 months, you could have a matter resolved. For example, it could be a property law issue between the spouses, and if the property involved maybe may amount to about $1 million, and you get a legal fee of 10% of that, that's a huge financial windfall for the lawyer. That could be settled quickly within a period of 3 months or so. This happens as well in relation to workplace injuries, where it is common for an employee or a worker who has been injured in a workplace to try to seek a settlement, for example, through with the employer or with the agency that is involved with the workplace compensation. And in that case, again, negotiations are involved, which can include not only discussions, but also the exchange of documents about the level of injury that a worker has experienced, and an examination of the proximate cause of such injury being in relation to the workplace. So negotiation, therefore, is one of the important alternative dispute resolution processes, and negotiations continue even when there might be a proceeding or an application before a court. Mediation also is another alternative dispute resolution process, which we examine in detail, I think, in week 3 or 4. And again, it is a very important ADR mechanism because it allows a third party to try to intervene between two disputing parties or individuals to try to arrive at a resolution. So sometimes negotiations fail and the parties between themselves cannot agree. And even when lawyers try to negotiate with each other, that will also fail. So they would need sometimes a third person to intervene to try to mediate, be at the middle, mediate, between the parties, hoping that there will be a resolution of the dispute. Conciliation, in a sense, is also quite similar to mediation in the sense that there is also a third party trying to facilitate a settlement between the parties. One of the major distinctions, however, is that when it comes to mediation, the mediator tries to focus on the process by which the parties may arrive at an agreement that they could live with, as opposed to conciliation, where not only is the conciliator facilitative, but he can actually try to push the parties towards arriving at a particular outcome. So in the case of mediation, for example, the mediator will avoid trying to suggest or even impose a solution, whereas when it comes to conciliation, it is typically part of the mandate of a conciliator to try to influence the parties to arrive at a solution, and that solution may in fact come from the conciliator himself. Now, going back to negotiation, by the way, and when we look at that in week 2, we will focus on a book written by Urey and Fisher, William Urey and Roger Fisher, on getting to yes. And we realized that oftentimes our understanding of negotiation may in fact be wrong, because they suggest that instead of positional bargaining, where you try to do a hard bargain or you bargain on the basis of your position, I want this to happen, and if you don't give it to me, I cannot, will probably not be able to arrive at a settlement. And what happens with positional bargaining is that it's often a win-lose situation. Somebody wins, somebody loses. They're suggesting that instead of focusing on positions, focus on principles, focus on outcomes you can live with. So it is actually a negotiation based on certain principles so that you arrive at what might be known a win-win solution, which actually means, as we see in week 3 rather, which actually tells us that when you focus on a principle-based negotiation, your goal would be to try to also understand the interests of the other party, so that by knowing the interests of the other party, you can both find a way to arrive at an agreement that you can both live with. So we're going to examine that as well. Now, the other ADR process that we focus on in this unit would also be arbitration. And again, in the case of an arbitrator, you again have a third party that tries to make a determination about the dispute. But in this particular case, that third person, or the arbitrator, in a sense, almost acts like in the nature of a judge, because there is an opportunity for the arbitrator to actually hear formally, or sometimes informally, the respective evidence of the parties. And ultimately, therefore, what happens then is that the arbitrator makes a judgment or a determination about a dispute before it. And that judgment can become, therefore, an arbitral award that is enforceable before the courts. And as I mentioned, in relation to arbitration, for example, it is typical for a lot of commercial agreements to embody or to have an arbitration clause, which requires the parties, in the event of a dispute, to go before an arbitrator instead of having to go to the judge. And as I said, there is benefit to having an arbitrator instead of having to go to the court, mainly because, one, the arbitrator can focus on the proceedings, so it could be faster. It will also be less expensive to come before the adjudicator, mainly because you potentially avoid a full-blown hearing. We will also be examining court-appointed referees, partnering, and dispute resolution boards in succeeding weeks. So far, we've covered, the fact that disputes are quite commonplace, they're pervasive in society, and given the fact that disputes and conflicts are a natural feature of life, we need to know the mechanisms by which we can try to resolve these disputes. Oftentimes, the fallback position for lawyers would be to seek a resolution of disputes by going to the courts through a judicial determination of a dispute. But there are, in fact, alternative dispute resolution processes, which we have just discussed. And as I mentioned, even when you talk about alternative dispute resolutions, it should be clear that an alternative dispute resolution is not necessarily outside of a judicial dispute resolution, because in many statutory schemes, ADR is now embedded as part of a judicial proceeding. Now, one thing we also need to learn is that ADR actually operates in the shadow of the law. So even when we talk about negotiation, even when we talk about mediation, conciliation, or arbitration, there is a role for lawyers, because negotiations, mediation, conciliation, or arbitration are done in the context of a knowledge of what the law is or what the law says. So legal knowledge is important. You don't negotiate without knowing what your legal rights are or what your legal liabilities might be. So there is a role for lawyers, because it's so difficult. You cannot operate using the alternative dispute resolution mechanisms without having a knowledge of the law, without having a knowledge of your own legal position. And of course, lawyers today are involved in the ADR process. So we always talk of alternative dispute resolution in the shadow of the law. It doesn't operate outside of the law. ADR operates within the bounds of the law. It just highlights the fact that a lot of disputes don't have to be resolved exclusively by the courts, and in fact, it is not advisable for disputes to often be resolved by the courts. In fact, in many cases, a majority of cases, perhaps between 80% to 85% of disputes are in fact resolved not by a judicial determination, but through an alternative dispute resolution mechanism. ADR is also in the shadow, operates also in the shadow of the law because, as I mentioned, a lot of the ADR processes are in fact annexed by the court. So, as I mentioned, in the AAT, it is commonplace for a proceeding before the AAT to first be subjected to mediation or conciliation. And in family law proceedings and in civil disputes, it is quite common for mediation and conciliation to be a requirement for a legal proceeding to continue. So, why ADR? As I mentioned, there are cost savings to resorting to alternative dispute resolution processes for the purpose of trying to resolve disputes. You avoid the full cost of having to pay for lawyers. I mean, if you go through negotiations with another individual with whom you have a dispute, then you avoid lawyers altogether. And even then, if you need to, even if you need to solicit the help of a lawyer, the costs will be less substantial if the parties avoid having to come before the courts. With ADR, there is also the desirable outcome of avoiding court-ordered costs to the winner, because by exploring the possibility of arriving at a settlement through an ADR and the parties arrive at a settlement on their own, then there is no place for the courts, therefore, to order costs to the loser. Because in a sense, it is a win-win situation for the parties in dispute. ADR also has an advantage in the sense that it avoids the emotional toll to the parties, given the fact that it is not easy for a lay person to have to be part of a judicial and legal proceeding, mainly because they are very uncertain about the law, uncertain about the procedure in a court proceeding. Whereas if it's an alternative dispute resolution, because of the facilitative manner, especially about concerning negotiation, mediation, or conciliation, the parties in disputes themselves have a stronger role in trying to arrive at a dispute. So the emotional toll would be less. There's also a reduction in uncertainty because the parties in dispute try to remove the uncertainty by arriving at a solution that they could both live with. And that would be better than having to rely on the judge to make a determination as to the respective rights and liabilities of the parties. So the judge will often say, you might be better, party litigants, you might be better off trying to arrive at a settlement, at an amicable settlement that you can both live with, instead of relying on the court, who will have to apply the law, even if it has to be rigid, in a way that may appear very difficult to live with by the parties. So the advantage of an ADR, of using ADR, is that because the parties in dispute are very much part of the process, they reduce the uncertainty by trying to arrive at a settlement or solution that they can both live with. The resolution can also be quicker. As I said, it can take a long time for the court to arrive at a judicial determination in relation to matter before it, whereas it is quite possible that from the time a dispute arises, a serious dispute arises between parties, they may arrive at a resolution within a period of 1 month to even 5 months, whether it's a parenting order or it's a property property law matter, or it could be about workplace injury and so on. So the resolution is quicker. There's also that aspect of the ADR, apart from arbitration, there's also the aspect that when you talk about mediation, conciliation, and negotiation, the processes are typically more informal and flexible. In a court proceeding, of course, we have to follow the regular court processes, which are very formalistic and inflexible. For the parties as well, it is less intimidating to undergo the ADR process, mainly because they're inflexible. And you have a third party who is not really a judge, but a facilitator who's trying to assist the parties to arrive at a settlement. So it is less intimidating for the parties. As well, the ADR provides the parties an opportunity to arrive at an agreed outcome that they can both live with. So there are a lot of advantages to resorting to ADR to resolve a dispute. Now, finally, why should you as students, law students, learn about ADR? Because, as I mentioned earlier, alternative dispute resolution operates in the shadow of the law. And you cannot try to learn, to undertake, to be involved in ADR proceedings without knowing about ADR. You need to know about conciliation, you need to know about mediation, arbitration, and so on. You also need to have legal knowledge and background as well of the law, certainly, because as we said, when you speak of negotiation, mediation, conciliation, and arbitration, these ADR processes are often done in the context of knowing what the law is and what your respective legal positions might be. We also need to realize that in many cases today, a lot of lawyers are actually actively involved in the ADR process as conciliators and mediators, and sometimes they also act as negotiators. So becoming a lawyer is not all about trying to seek a resolution of a dispute before the courts. It's also about learning how to use ADR processes in order to fashion a settlement of a dispute. And as I mentioned as well, you need to learn about ADR because a lot of the court proceedings require the use of ADR processes before the parties are able to continue or proceed with a judicial proceeding. Now, I wish to point out that in the succeeding tutorial podcasts, we will rely on the tutorial podcasts prepared by John Milburn, who is the regular unit coordinator for LAWS11068. So it is only in relation to the week 1 podcast that I have taken the trouble or undertaken the task of preparing the podcast. But in future podcasts, we rely on the podcasts made by John Milburn. So, on completing this tutorial, you will have been able to discuss and explain the unit learning outcomes and unit topics, the role of ADR in conflicts and conflict resolution, what ADR is, the types of ADR, the benefits of ADR, and why lawyers should learn about ADR. And so before I close this podcast, I wish to welcome all of you again into this unit, and I am excited to be your unit coordinator, and I look forward to engaging with you more in the days ahead through our tutorials and through our exchanges by email or on Moodle. See you soon. My name is Manjo Oison. Again, I'm your unit coordinator. See you soon.